All right, we're here for another Tuesday after school session, prepping for the AP government exam. So now we're into Unit 3, so this is a bonus review. Get it? It's not a typo. All right, hopefully you get it. All right, so today we're going to talk about symbolic speech. Of course, we'll talk about this in class, but this gives you a good primer, if you will. So, symbolic speech is speech that is nonverbal. So, no one's saying it, no one's speaking it, and it's also not written. It's not in a letter, it's not in a newspaper, a pamphlet, anything like that. So, if Uncle Sam up here couldn't speak because he had something covering his mouth, and suppose he couldn't write because his arms are hand down, could he still speak in other ways? Well, probably not if he's tied down, but you get the idea. All right. So, what other kinds of speech are there? Now, there is a type of speech with a court case that I'm not covering here today, but that means speech via how you spend your money. So that just know that this does not cover everything that we're going to cover this year when it comes to symbolic speech. So let's give you some examples besides how you spend your money of symbolic speech. Flag burning, right, is a form of protest. Burning draft cards, which was really popular during the Vietnam War. And of course, wearing armbands, which has been a sign of mourning, a sign of protest, and various things. There's countless other examples. Okay. Now, symbolic speech is regulated more than traditional speech. So even though you have a right to free speech and symbolic speech is covered under that, remember, every right is still regulated to some degree, right? The Second Amendment is still regulated. Um, the freedom to assembly is still regulated. You can't just all gather in the middle of a highway when you feel like it, right? The right to free speech is one of the least regulated ones, all right? Or but it still does have regulations, and symbolic speech is regulated a bit more than traditional speech. So when it comes to not flag burning, the burning of draft cards, this is not an AP Gov requirement. Required case. It's still good to understand. It's often used as an example, also as the flag burning case. But the U.S. v. O'Brien, this was 1968, and the 60s dealt with lots of civil rights court cases before the Supreme Court. And the Supreme Court ruled that symbolic speech does not protect the burning of draft cards, that is not, that people don't have the right to burn their draft cards. Well, how? They said because the state has a legitimate interest to protect draft cards. There's information on there, and that information can help with the execution of the war. So draft cards are critical. This is a critical point of the war. It is of interest that they are not burnt. So, because of that state interest, burning draft cards was not considered free speech, or was not protected free speech. And the Supreme Court here came up with a four-part test. You're never going to be quizzed on this, but this is supposed to be a college class, right? Right? So you should know about this. And when they look at should this symbolic speech be protected or not, it's, well, is the law against it? Is it within the constitutional power of the government? Right? Can you even connect it that the government has this constitutional power? Does it help with a important government interest, right? Like protecting that information during wartime. Is this interest unrelated to the suppression of free expression, right? It has to be something separate from that. And is this regulation the least restrictive means? You see this in Supreme Court cases often. When you have to tailor something that might otherwise be a violation of some sort of freedom, it has to be narrowly tailored to be the least restrictive possible. And is that? Now, let's be honest, this four-part test has not withstood the test of time. There's been many cases where they're like, hey, this four-part test doesn't apply. Just like the Lemon test doesn't really apply to freedom of religion cases anymore, but you're still supposed to know about it, right? So there we go. So this is one of the required court cases. We're going to keep talking about this year. This is Tinker v. Des Moines. This is 1969. So you see just right after the draft card case. This is also connected to Vietnam because these high school students were protesting the war in Vietnam and its expansion in 1969. So these kids got in trouble from the school because they wore these armbands. But the court rejected the school's argument that it needed this regulation to maintain order. They said these armbands are not disruptive. These kids aren't protesting. They're not walking out of class. They're not shouting. They're not doing anything except wearing these armbands. Therefore, it's just like wearing, a piece of jewelry. So therefore, it doesn't actually disrupt the educational experience. If it did, it may have had a different holding. And the court held that this ban was therefore suppressing student expression, and it is therefore a violation of the First Amendment. You'll hear that saying that Tinker Des Moines showed that your basic rights does not stop at the schoolhouse gates. To be honest, there have been many cases since which have shown that schools are able to regulate those rights to some degree, but not in this case, not in Tinker. So something we also want to discuss is when it comes to freedom of speech, right? In symbolic speech, there's other types of symbolic speech that have been even more controversial. Um, and how do we do this? Hey, what happened to my flag burning slide? Huh. Here we go. Texas versus Johnson was flag burning. This was a big case in 1989. I even remember as a kid what a big case this was because even kids like me follow these news stories back then. Hold
This
on.
is a test of the PA system. This is a test of our PA system.
We hear you, Mr. Johnson. All right. So this case was about people protesting by setting the flag on fire. Now, 1989, this is during the Cold War. Vietnam is over with, so to speak.
All right, testing the PA system has commenced or concluded.
Thank you, Mr. Johnson. All right. So when people were protesting by burning the American flag, this really angered a lot of people. And especially think in 89, you still have a large number of World War II veterans still alive, even some World War I to some degree, and other veterans. And it angered people who even weren't veterans. How can you do this? So Texas said, hey, this is illegal. You can't do this because we want to preserve the flag as a symbol of nationhood and national unity, and burning it is against the law. Well, this went to the Supreme Court, and the Supreme Court said, hey, you know what? We might not like this, but you can't ban it. And the ruling was 5-4. And remember, we learned that whenever it's 5-4, that means it's pretty controversial. It's not really settled. Maybe it could even be overturned if brought back to the courts, if you have a change in your makeup of the court. So Justice William Brennan, who wrote in the majority, said, if there is a he wrote this in his opinion. If there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable, right? You don't have a right not to be offended. Okay? Lots of people are going to be offended by burning the flag. Lots of people find it disagreeable. Lots of people just don't like it. Lots of people find it wrong. And even some of the justices were like, we find it wrong. But just because we morally find it wrong doesn't mean it's unconstitutional, right? And they still have the right to do it. And we have the right to say why we don't like it. Now, we have the right to be upset about it. All right. So, continuing with that, I'm sorry, this went out of order. We have fighting words. So this is 1992. So think once again of you don't have the right to not be offended. And this brings it into even more uncomfortable territory. And we could discuss this more in depth in class. But now think of, we're going to talk later also about hate speech. And is hate speech protected, or can hate speech be banned as well? And there's two cases here. RAV, that's a teenager's initials that didn't want to become public, in 1992, just a few years after the flag burning case, right? It upheld an ordinance prohibiting fighting words that were racially motivated was unconstitutional under the First Amendment. This dealt with cross burning, right? So think of racially motivated actions. That was symbolic speech. And unanimously, the Supreme Court was like, we don't really like this, but you can't ban this. You can't ban speech. It has to be like a threat. And not just a threat, it has to be like a threat that you think you're going to get hurt immediately. Not like it's saying, hey, someday in the future, we're going to get you, right? Unless that cross burning was that kind of threat, the Supreme Court was like, you can't ban it. This came back again in Virginia versus Black in 2003. And this dealt with cross burning. Now, the background to the cases are different. We can talk about that in class. You can Google them. But once again, the court did not declare it illegal to burn crosses, but this time you do have one person who dissents, and this is Judge Thomas, who was an African American, still is an African American on the bench. So go look up, was he on the bench in 1992 or not? And you can read his dissent, and he talks about the history of the KKK, and the court protects messages of shared ideology, which is supposedly like what this cross burning was. And you can disagree with that shared ideology, but let's look at threats of intimidation, and let's look at the history of what the KKK has done, and then you can see that as a serious threat.
Hey,
Hi.
are you with your students right now?
Yeah, they're all here waiting to learn.
Sorry to interrupt. There's not.
That's all right.